So over the last couple of weeks, there have been a number of headlines relating to the judiciary, the way courts operate, in particular, certain decisions and issues which emerge. And I wanted to look at this from the Beth Din perspective, and in particular, the idea of being held in contempt of court, as well as what happens when decisions leak. In the first headline from the source sheet, Trump held in contempt faces $10,000 per day fine in New York AG's probe. A New York judge on Monday held Donald Trump in contempt and fined him $10,000 a day for failing to comply with a subpoena for documents and Attorney General Letitia James' probe of his company's business dealings. Mr. Trump, I know you take your business seriously, and I take mine seriously. I therefore hold you in civil contempt and fine you $10,000 a day, said Manhattan Supreme Court Justice Arthur Engoron before striking the gavel. All right, this idea of being held in contempt is something any of us who have ever either spent time in courtrooms or watching courtroom dramas is familiar with. The idea of being held in contempt for violating some form of judicial order or the like. And that is the fact that it was Donald Trump being held in contempt certainly caught more people's attention. But for our purposes, the discussion is about contempt, not who it is or for what the investigation is, but it certainly raised the issue of contempt to something higher on our radar screens. Second headline, and of course, this is also hot off the press in the last week, Supreme Court has voted to overturn abortion rights, draft opinion shows. It's a lesson in headline writing, because the Supreme Court hasn't voted, but there's a draft decision that was leaked. But you know how to get everyone's attention. Supreme Court has voted to strike down the landmark Roe v. Wade decision according to an initial draft. The majority opinion written by Justice Samuel Alito circulated inside the court and obtained by Politico. Deliberations on controversial cases have in the past been fluid. Justices can and sometimes do change their votes as draft opinions circulate. Major decisions can be subject to multiple drafts and vote trading, sometimes until just days before a decision is unveiled. The court's holding will not be final until it is published, likely in the next 2 months. So, of course, we know that this has roiled the nation, and the discussion are ongoing, and protests are ongoing, and what this means. And as I mentioned on Shabbos, I think I'll wait for the final decision to maybe talk more about the issue. But there are, obviously some very strongly held views, and it is interesting what the Jewish community's response will be, what the Halachic community's response will be. If anyone is interested, I thought there was a very well-written piece by Rabbi Avi Shafran from Agudath Israel in why he and Aguda feels Roe should be overturned, without recognizing the complexity of the issue of abortion in Jewish law. But for our purposes, what does it mean for there to be a leaked decision, or a decision in general, or having things written out? And from a Jewish perspective, maybe look at the differences between a Beit Din decision and a Supreme Court decision. But here are two, judicial areas of operation: contempt in the one case, judicial leak on the other, and what would happen in Beth Din? What's going on in Jewish law with regards to both of these issues? So we'll start with just looking at the idea of contempt. What is contempt? Right, contempt, kind of hatred. You're showing contempt of the court by ignoring or violating its parameters or its instructions. So here's a definition of contempt of court from the Cornell Law School website. Contempt of court is the disobedience of an order of a court. It is also conduct tending to obstruct or interfere with orderly administration of justice. Contempt of court can also be classified as civil contempt or criminal contempt. For example, in Pennsylvania, if a court's purpose for finding contempt is to coerce a contemptor to comply with the court's order, then the charge will be one of civil contempt. However, if the court's purpose is to punish the contemptor for disobedience, then the charge will be one of criminal contempt. So civil contempt. Maybe if sometimes you see the journalist is ordered to turn over their sources and they refuse, so they'll be held in civil contempt. Punishments for contempt include imprisonment and fines. However, according to the Supreme Court, civil contempt penalties are conditional. Those who are punished for civil contempt can avoid the punishment by doing as the court ordered, and they are therefore described as carrying the keys of their prison in their own pocket. Punishments for criminal contempt, however, are generally unconditional and definite. Think about someone who is disorderly behavior in the court, which is on some level criminal. It's forbidden and is held in contempt. There's a punishment associated. There's no way to get out of that punishment. Civil contempt, you're being demanded to do something and you're not doing it. Well, you do the something and you get out of the punishment. And Jewish law has a parallel series of laws as it comes to the orders of the Beth Din being followed and what happens when you violate. And often this is first seen with regards to a summons. What happens when the Beth Din summons someone to appear in court or appear before the Beth Din and they don't? So Gemara and Bava Kama presents this scenario. Source number 2. Ravina said, we deem an agent of the rabbis who was sent to summon an individual to court as credible as 2 witnesses if he says the defendant refuses to come to court. All right, Beth Din summons, the individual summons Ruvain to court, and they send the agent to go tell him that, and the agent says, the agent reports back that Ruvain said, I'm not going. Right? Usually testimony requires 2 witnesses, but here, if Ruvain tells the agent I'm not going, and the agent reports back to the Beth Din that Ruvain is not going, that is believed as if as the power of 2 witnesses. And this matter applies only with regard to excommunication. And therefore, the Beth Din would have the power to hold him in contempt, or the Beth Din version of contempt, which is excommunication. But with regard to issuing a document of ostracism, since this causes the defendant a loss of money, as he must pay the sofa for drafting the document, the agent is not deemed credible. Right? So the idea of finding him in contempt to excommunicate him, we're done. And therefore, the agent can report back that the Ruvain doesn't want to go to court and he's excommunicated. But with regards to issuing a document of ostracism, the fact that it's basically a proclamation that Ruvain isn't coming to court, the proclamation can be much more harmful in the fact that it gets sent all around the fact that he is refusing to attend. And he's responsible for the sofer costs, the cost of the scribe to draft the document. The agent is not deemed credible. So if the Beth Din sends an agent to Ruvain and says to come to court, and Ruvain tells the agent no, the agent can report back to the Beth Din that Ruvain is refusing, and the Beth Din can then excommunicate him. But the Beth Din can't have written in a document of ostracism, because that money would end up coming out of Ruvain's pocket, and we're not going to rely just upon the agent to penalize Ruvain and cause him to pay. It's one thing to declare excommunication, it's another to cause Ruvain to pay. For that, there's a higher standard of evidence that's required, and even though both present the situation of Beth Din demanding Ruvain appear, agent delivering that message, Ruvain refusing in front of that agent, well, the agent is enough to excommunicate Ruvain, but the agent is not enough to write a document of ostracism, because that requires a higher burden of proof, requires 2 witnesses. That was Ravina. Rava said, with regard to one who had a document of ostracism written for him because he did not come to court, we do not tear up the document until he actually comes to court. Right? Another situation when you had that document already written, that Ruvain is refusing, and if Ruvain then says, no, I'll come, we don't tear up the document. It's not enough for him to commit to appearing. Similarly, if the document of ostracism was written because he did not obey the ruling of the court, we do not tear it up until he actually obeys the ruling. Right? You can't just say, I want to. The Gemara comments, this second statement is not so. Right? If the document of ostracism was written because Ruvain is not obeying the ruling, right? The court, rather, once he has acquiesced and says, I will obey, we immediately tear up the document. Once he says he will listen, we tear up the document. We don't wait for him to actually follow through. All right, so there's a little bit of a parallel with what the civil contempt penalties that we saw above in source number 1, right? Carrying the keys of the prison to their own pocket. Here, if he's refusing to obey the ruling of the court, and he says he will, that's enough to get him off the hook and tear up the document. Now, what happens if he then becomes a liar? Well, then the whole process starts again. So we're dealing with, again, Talmudic law. We're dealing with a situation of Beth Din making demands. We're dealing with a case where the person they make the demands of, let's call him Ruvain, refuses. There is the standard of the burden of proof for excommunication, which is just refusing to appear. And there is the burden of proof to write the document of ostracism, which requires more because it will then take money out of his pocket. There will be a financial penalty imposed. And we see the second rule, which has a parallel with contempt, that if he acquiesces, everything is torn up. And but if he says he'll show up, it's not, the excommunication is not removed until he actually shows up. If the order has been written that he's not agreeing with Beth Din, and he says I will agree, they tear it up immediately, which seems to be a more liberal way of getting out of contempt than in the civil situation. But that is how the Talmud presents it. We'll just stop here for some reaction or comments to the cases or to this Talmudic text before looking at how this gets applied, according to the Shulchan Aruch. So you might be wondering, how often do these cases emerge? Well, I would say that, the Beth Din system, whether it be in America or in Israel, is a fairly robust system. We sometimes encounter it mainly with regards to, most commonly in our, reading about it, it has to do with divorce, with the get process, which has other variables thrown in, but it's also not uncommon for, if two Jews have a financial dispute, that dispute should be handled in Beit Din. And there are rabbinic courts, in particular the Beth Din of America, which has expertise in adjudicating all sorts of financial disputes. Not because you shouldn't be imagining 3 long bearded rabbis who know how to handle and deliberate about serious financial transaction legalities, but because we live in a world where rabbis have also received educations and can be experts in areas of secular law or business and finance. In the Beth Din of America in particular, often graduates of Yeshiva University who went to rabbinical school there, but also went to college there or received advanced degrees, are familiar with the legalities as well as the halacha, and will adjudicate a case, which is in fact what Jewish law demands when the two litigants are Jewish. Right? In Parshat Mishpatim, we encounter the various serious and harsh language about Jews should adjudicate in Beit Din according to Jewish law, as opposed to take things to the secular authorities. We talked about some of the way this developed in terms of maybe a disdain, when the secular authorities weren't really there to apply law equally to Jews, and that could have been one way that this developed. But the halacha is, and the significant, it's a Talmudic and Jewish legal source material for how to deal with these cases. And it's not just the two Jews fighting over the talus, as the Gemara in Bava Metzia begins with, but there are ways to have these cases adjudicated. Very often, the way it's handled from a legal perspective, so that this adjudication in Beit Din and its decision will be recognized in a secular sense, is that the two parties agree to take this on in the form of binding arbitration. And many states have laws that these types of cases can be arbitrated, and that will be binding, and that will be registered and validated by the courts. And those arbiters have a certain amount of legal standing, and so that including a Beth Din. Similar the situation in Israel. Israel, of course, the whole Jewish legal system has an advantage of being a Jewish state. But so more often than not, we encounter terms relating to contempt or refusal with regards to when people flagrantly ignore coming to Beit Din. The terms you may have, first one is cherem, that's the excommunication. And this idea of ostracism is called seruv, which is when a party refuses to show up. And we see that there are penalties imposed for both. A person can be excommunicated for refusing to show up. A person can have a document of seruv issued against them for refusing to participate. And these terms and concepts are still applied. It's again, I think we encounter it in the Jewish world, in the press or in the public realm with regards to get refusal, where a person can be put into cherem or a seruv is issued when they refuse to show up at Beth Din, but that's how it applies. One thing that's I think probably obvious to all of us studying the subject, right? The Beth Din doesn't have the same authority or strength, communal strength as it once may have had. Right? These days, the Jewish community is not so centralized that a declaration of a Beth Din would have the same level of impact on a defendant who is or a litigant who's found to be in contempt or refusing. Right? These days, if someone is held in excommunicated in one place, they could just go to another. Or if one Beth Din says you have to come, the person can say, well, I don't like that Beth Din. That's not my Beth Din. I'm part of another community. And so that ostracism document also has has fewer teeth or more blunted influence than it may used to have had. And in fact, the Beth Din isn't always very willing to flex this type of muscle or issue these types of declarations, hold the person in contempt because of the inability to deliver or to punish, and that just weakens the overall system. Miriam, question?
Yes, I do. Is there any places in halacha where we have a financial penalty or a fine for not?
So I think as we go through the sources, we'll see that there's a lot of judicial discretion. The halacha doesn't state certain knas of X amount for it. A lot of that is in the discretion of the Beit Din. And
does it actually occur today? Does that occur today? Does that occur today? Are there fines?
So I think part of that is, the short answer is yes. The longer answer is it depends on the case, and also who's involved in terms of whether there's a sense that the power is no longer necessarily in the hands of the Beth Din because of the fact that the litigants can go elsewhere or can refuse. I think the only time there's more, the Beth Din has stronger teeth is when the Beth Din has stronger legal standing. And so if two parties sign for a binding arbitration agreement, that may increase the standing of the Beth Din in terms of how it relates. But usually, remember, that type of an arrangement is when both sides are ready to commit. It's in Israel where the rabbinical courts have been given this ability to punish. Most of the time it comes up in divorce situations, where in Israel, if a husband is refusing to give the divorce, he can have his driver's license suspended, he could have his credit cards canceled, he could be put in jail. And the like, and so cases like this have taken place. Recently, there was a case in Israel where a person had not given the get and had even withstood a lot of these penalties imposed by Beth Din, but finally agreed to give the divorce. And after he gave the divorce, he said, "No, I didn't really want to give the divorce." But the case had already been finalized, and the Beth Din said that the divorce was final. So I think the ability to really impose it is when the Beth Din legal standing is such that its decisions are actionable. And again, the only way it's really actionable is when the government stands behind it.
Right.
or if there's a strong enough communal structure, right? In some of the communities that, especially, let's say in Hasidic communities that are very much, there's a strong communal structure that you're in or you're out, those types of declarations will have more standing.
Right. Thank you.
Rabbi,
Yeah.
what about the President of the United States? He is not above the law. That's a frequently cited quotation regarding the president. And if he were to refuse to comply with a subpoena, he would be subject to the same penalties as any civilian would be.
Well, I think the law is the same for all. I think the same in civil law as in rabbinic law. The question is, when does the judicial process come to an end? Right? Someone is found in contempt. They can appeal that finding and or the penalty for them being held in contempt. So I think that just like no one's above the law. The law is not final until a person finishes, is able to exercise their full rights within the law. Now, in terms of a president being above the law, there are certain cases about, with regards, they talk about it might be difficult to indict a sitting president. We never really got that far. We talk about impeachment, but there are all sorts of things that go way beyond my familiarity with American law, as to just like as Mel Brooks said in History of the World Part 1, it's good to be the king. It's probably good to be the president too. There probably are certain advantages in addition to all the pomp and circumstance. So let's see how this plays out, practically speaking. Source number 3, the Ramah, one who states that he is not afraid of the court order or the sage. The law is that although he does appear in court for trial, they place him under the ban, for since he states that he comes not on account of the court order, it's regarded as contempt of the law. Here it seems that in a Beth Din situation, Jewish law is standing up for the honor of the rabbis, right? He shows up and says, I don't really believe in your authority, but I'm here anyway. They'll hold him in contempt. Now, you could say it's the rabbis who are writing these laws or stating these laws that will then be to defend their honor, but we know that is how the Jewish legal system does work with regards to rabbinic law. And so here it's not even about the Jewish law really expects or demands from the litigant a respect for the court, right? The declaration order in the court takes on a whole different meaning when there is a demand for respecting the court, and if that goes unheeded, there can be consequences or could be penalties just from that alone. So Talmud in Kedushin source number 4, Rav would flog a man for tormenting. Tormenting can either be maybe behaving irreverently toward a messenger of the sages, as this indicates a lack of regard for the sages. It's not just ignoring the court or refusing to follow their rules. It's also denigrating the court. And it seems that Jewish law is trying to maintain a reverence and respect for the court on the higher level. So much so, that really, similar to the different penalties that can be imposed in civil contempt or even criminal contempt, where there's a lot of leeway and a lot of discretion as to the penalty imposed, Jewish law has the same thing. Source number 5, the court has the authority to impose stringencies upon one who's been excommunicated, that his son shall not be circumcised, he should not be buried with honor if he dies, to expel his children from school and his wife from synagogue until he accepts himself of the law. If they see that by this they will bend his head, they'll secure his submission. But in the absence of such considerations, we do not punish children because of their parents and wife, because of their husband, even small children. Right? And we actually spoke about this, about children being punished for the sins of their parents. And the Aruch HaShulchan is making a couple of points with regards to contempt or excommunication or ostracism. You do what you can to force compliance. However, you don't punish other people if it's not going to force compliance, right? If doing all these things will not lead to the individual to yield, right? You can punish him, but you really shouldn't be punishing his wife and children unless they may actually have an impact. So the Aruch HaShulchan is more broadly stating, we do whatever we can to coerce and force or lead to this litigant submitting to the authority of the court. However, sometimes we have to acknowledge our limitations, and if it's not going to work, we can continue to ostracize him, but maybe we shouldn't do it to his children. Again, the Aruch HaShulchan also pointing out there's a lot of discretion here, right? There's no specific time limit that leads to a certain consequence being applied, but in general, we can sum up by recognizing that Jewish law has a similar approach to contempt. It does not want to, there's a higher threshold that needs to be crossed for the litigant to be fined or to pay a certain penalty. Which, may make it a little bit more flexible, than secular contempt. However, the Jewish law does place a premium on respecting the court and will punish even for disrespect of the court, even if it's less than ignoring or refusing to show up or to follow a law. Even disrespecting the court can trigger these types of consequences and penalties. And so that's, with regards to contempt. Any reactions onto contempt before we talk about the procedures of the Beth Din of maintaining the privacy and the integrity of deliberation and decision? Okay, so I think we could probably expect that deliberations of a Beth Din should be private. Just like there's a lot of displeasure at this the Supreme Court's deliberation or draft decision being leaked, right? It causes a whole brouhaha, causes a whole uproar. Is this the final decision? Who leaked it? What happened? Et cetera, et cetera. I think Jewish law also is there to both maintain the integrity of the deliberation process as well as protect the privacy of the litigants. And we see that in source number 6 on Sanhedrin 29a. From where is it derived that when the judge leaves the courtroom, he may not say, I deemed you exempt and my colleagues deemed you liable. But what can I do as my colleagues outnumbered me and consequently you are deemed liable? About this, it is said, you shall not be a talebearer among your people. One who goes about as a talebearer reveals secrets, but one who is a faithful spirit conceals a matter. Really, the Talmud is interested in, it doesn't even matter, you don't even publicize who decided which way. Right, we see there's significant differences between the way a Beth Din adjudicates and concludes and the way courts do, and the Supreme Court in particular. Right, at the end of a case, if there's a 2-to-1 decision, the one who dissented shouldn't say, I dissent and I wish you were innocent, but what can I do? Everyone disagreed. That's not meant to be. These are, in a sense, Beth Din decisions are unsigned decisions. We don't know who voted for what. And in addition, we don't really want there to be other people who are part of the deliberation process. Source number 7. If one of the litigants produce witnesses to substantiate his pleas, and they bring in the witnesses and receive their testimony properly, and after they receive their testimony, they should order every person out and discuss the case. Right? We're not looking for kibitzers. We're not looking for people to be present to interfere in the deliberations. We don't want there to be any kind of outside influence. Now, Rabbi Yoshua Falk, one of the commentaries to that law in source number 8, mentions that we don't want, we basically, because we don't want anyone around who may inform. We don't want anyone who's in the courtroom to then be able to leak what the deliberations are, who's guilty and who's innocent. Or it could be that if there are people who are present for the deliberations, maybe one of the principals in the case will yishma'u habalei din divrei masa u'matan shel dayanim. They'll hear the deliberations. When we talk divrei yilmadu liton sheker, and maybe they'll try and change their claims. Right? We don't want there to be any sense of what's being discussed, because that could influence the behavior of the litigants. That may change the overall shape of the conversation. And in a sense, the Jewish law is demanding a certain level of privacy, and that the deliberations and the decisions are going to take place behind closed doors and in an empty space, because we don't want there to be any type of leaks that may either provide false information or incomplete information to the litigants, or to lead the litigants to change their stories or change the overall course of the case. It was just interesting. There's a lot of discussion as to who leaked the Supreme Court draft. So source number 9, former press secretary for Hillary Clinton, executive director of Demand Justice, Brian Fallon, speculated Wednesday that a brave clerk may be the source of this recent Supreme Court opinion leak. Is a brave clerk taking this unprecedented step of leaking a draft opinion to warn the country what's coming in a last-ditch Hail Mary attempt to see if the public response might cause the court to reconsider? Fallon continued praising the leak and urging similar tactics in the future. The former Clinton aide called the court wholly unaccountable and encouraged citizens to rip the veil off SCOTUS deliberations. Right? So in a sense, it could be people are trying to shine light on the deliberations, or change the nature of the conversation, or maybe even put pressure on the judges. And some see that that's a good idea, right? Some have also suggested that now that it's out there, one or two things will happen. Well, we as we can imagine, either there will be pressure on the justices who have already, who seem to have solidified and coalesced around their opinions, to stick to their opinions or to change their opinions. And that's, what Jewish law is trying to avoid in maintaining the secrecy or the confidentiality of the discussions, and what in this case has led to so much controversy. Source number 10, and from where is it derived regard to a judge that a student who's an ignoramus should not sit before him to discuss the proceedings? It is derived, as the verse says, distance yourself from a false matter. When an ignorant student engages in the proceedings, he's apt to cause the judge to err in judgment. This is talking about an ignoramus, an improper student. But the Shulchan Aruch takes this in a direction that, maybe we don't want anyone within the deliberations, because that could lead to one of the judges being misled or getting a false idea into their head with regard to deliberation. This is something that was discussed by Rabbi Yaakov Reisher. The analogous case may be like, what's the role of the clerks in this situation? Are they in the room when the justices deliberate? Are they not in the room? Do they have too much influence? Do they have zero influence? And Rabbi Yaakov Reisher points out that from a Jewish legal perspective, that what we're looking to avoid are any rabble rousers or people who will create improper conversations. But if you have the right type of a person, that's one thing. If you have kind of like, the law clerks, those are not improper students, those are proper students. That Rabbi Yaakov Reisher is saying that there's kind of an analogous situation to law clerks in the Beth Din process, and those Talmidim have a right to participate. Now, it seems that so we have the same type of a situation. How much openness is there in a Beth Din discussion? Is it just the judges? Should the room be cleared? Is there room for students? Well, students, can they participate in the discussions? Right? These are all questions that we have, that there is kind of a veil on the Supreme Court. And a lot of that has to do with what kind of trust we have in the institution or not. Now, for the most part, when you talk about what kind of trust we have in institutions, I think the trust that Americans, according to polls, have in Congress is pretty low. And it could be because everything is, broadcast and publicized and the like. Some of C-SPAN is very boring, but it puts everything out there. Freedom of information and transparency can be important. At the same time, under the bright lights of public scrutiny, sometimes it could also lead to a less than full appreciation or approach to the subject. And just like it is an issue in secular law, we see Jewish law also grappling with the issue. And for the most part, as we saw with contempt, a lot of this has to do with the respect, the dignity, and the integrity of the court being maintained, and a certain recognition that the litigants or the public don't have a right to intrude upon the deliberations. Interesting that this case was leaked, and we're not sure we're going to see a decision for several months. Jewish law demands a more immediate decision. Source number 12, Sanhedrin 35a. If we say we should judge him on Shabbat Eve, conclude his verdict on Shabbat, and kill him on Sunday, you're bound to have caused a delay in the verdict, and the accused will have to wait overnight knowing he's condemned to death. We don't want to wait, right? We shouldn't postpone. When the verdict is ready, the verdict has to come out, and it just has to be announced. You could say that in the Supreme Court, this is not a verdict, this is just a deliberation, but it seems that in Jewish law, there's it's viewed as desirable to cut to the chase and get to the verdict as soon as possible, with appropriate deliberation, but not an undue lengthy process. And that's why the Shulchan Aruch concludes the judge is obliged to issue the verdict forthwith, immediately, after it becomes absolutely certain to him. For if he delays judgment and unduly prolongs the examination of established matters, in order thereby to afflict one of the litigants, such a one falls into the category he shall do no unrighteousness in judgment. And so therefore, you get to the decision, be done with it already. And it's always, I've always been a little bit confused why things take so long in the Supreme Court. I'm not in there, so can't tell you. I would imagine they're doing the best that they can, but there is an amount of deliberation or deliberateness in the length of the process that Jewish law would seem to encourage moving forward so that we have a decision as expeditiously as possible. Another area of difference, that may lead to the slower or the longer process and the lengthier process has to do with opinions, right? The fact that the Supreme Court issues written opinions, and they're generally long. I don't know if anyone has read an entire opinion. I don't know if anyone read this draft opinion. I have not. I imagine it's a law school thing for people who have a lot of interest in law. But the Supreme Court has a long tradition of written opinions. And you see the different types of opinions the Supreme Court has in source number 4. Right? Opinions refers to several types of writings by the justices. The most well-known are the opinions of the court announced in cases in which the court has heard oral arguments. Each sets out the court's judgment and its reasoning. The justice who authors a majority on principled opinion summarizes the opinion from the bench during the regularly scheduled session of the court. Shortly thereafter, a copy of the opinion is posted on the website. The court may also dispose of cases in per curiam opinions, which do not identify the author. These opinions frequently involve cases summarily, often without oral argument, but they've been issued even in important argued cases. Bush v. Gore and the campaign finance case of Buckley versus Vallejo. In chambers, opinions are written by individual justice to dispose of an application by a party for interim relief. Justice may also write opinions relating to the orders of the court to dissent or to concur, right? And then this is all printed and written up, etc. Jewish law does not demand that same level of thoroughness in decisions of the Beth Din. Right? Shulchan Aruch, source number 15. Some say that if the judge sees that a litigant entertains a suspicion against him, the judge turned the verdict against the litigant, then the judge is required to inform him the grounds in which he made his decision, even if the litigant did not ask for this. Right? So let's say, the person is, the Beth Din rules against the person. The Beth Din just has to say who it rules in favor of, it has to say nothing else. And the Shulchan Aruch says, some would say that if you're worried that the litigant will be displeased and fight the verdict because you don't explain it, then you need to explain it. Some say Beth Din doesn't have to explain its reasoning. The Ramah points out, however, some say that this is accurate only if they tried him by using means of coercion for him to appear in the court, right? But otherwise, they do not write down the grounds of their verdict, and thus is the fundamental principle. That in general, the Beth Din does not have to write down its decisions. You don't need a written opinion. It is not necessary to write down for him the reasons and the proof which led to the decision, but only the pleas of the litigants and the verdict of the judges are recorded for them, for the litigants. So you just have to write down guilty, innocent, how much. You don't have to write that. You don't have to really explain yourself. And this is something that clearly is not the way of the Supreme Court. but really, it seems as if we are, heading in Jewish law is about issuing the psak, the verdict, the decision, and that's that. It has to be followed. It doesn't matter the rationale. If there's a certain suspicion, maybe then the Beth Din has to be. Even so, you keep it tight. You keep it straight to the point. Now, it's interesting that the Israeli rabbinical court system has taken to writing up the decisions, and they are available. That, for example, nowadays the Supreme Rabbinical Court will only take cases where the lower courts have a written explanation that can then be reviewed by the higher courts, and the Supreme Rabbinical Court, the Beth Din Hagadol, will also not just say we accept or we reject; they also write it up. And some have said that this whole the ecclesiastical courts of Israel are kind of modeled after the Ottoman Empire. That its ecclesiastical courts also had written opinions, and that even though the Shulchan Aruch and the Ramah are talking about the letter of the law, there does seem to be a recognition that we live in an age maybe where people are more educated and demand to have a certain better appreciation of the rationale, and not just guilty, innocent, find in favor of the defendant, find in favor of the plaintiff, and the like. And which certainly has, I think, certainly has been the case with regards to when we see responsive literature has definitely influenced that as well. A question gets asked, it's often to be fully explained and to become part of the halachic process. Being able to defend it and source the material has become something much more palatable and recognized as valuable even in the halachic verdict process, just like in the Supreme Court. Again, the time frame, the encouraged time frame in the Beth Din is meant to be a lot faster, but so there are certain similarities. That in general, we want to keep things private. We don't want things to leak. Again, a lot of that is to maintain the kavod ha-Beth Din, the honor of the Beth Din, and I think there's a certain kavod that still is connected to the Supreme Court. Now that things are much more partisan and people don't, will not get the decision they like, that could be diminished. But they're still made, just like there's an honor for the court, which allows contempt findings to be issued. There's a certain honor and respect for the court in terms of the integrity of decisions coming out when they should, as they should, how they should, without any interference from leaks or kibitzers or clerks or anything like that.